Hello and welcome back, and thank you for joining us at HCCH Codify Edition 2023 on CBDC, Central Bank Digital Currencies. Now, this session, we're in conversation with Professor Fabrício Polido. Fabrício Polido is Associate Professor of Private International Law, Comparative Law and New Technologies at the Federal University of Minas Gerais, UFMG, in Brazil. He is Fellow and former Director of the Center for Postgraduate Studies in Law at UFMG and Director of the Center for Transnational and Comparative Legal Studies at the same university. Fabrício Polido has a doctoral degree in International Law summa cum laude from the University of Sao Paulo, a master's degree from the University of Turin, and a Bachelor's of Law degree from the University of Sao Paulo with exchange studies at the University of Tübingen. He was visiting fellow at the Max Planck Institute for Comparative and International Private Law in Hamburg, the University of Barcelona, the University of Kent, the Weizenbaum Institute for the Network Society in Berlin, and the Universität Humboldt zu Berlin. Fabrício Polido was a member of the Brazilian delegation to the Special Commission meetings on the Judgments Project from 2016 to 2019 and is currently a member of the Working Group on the Jurisdiction Project for the Hague Conference on Private International Law. Now, Fabrício Polido is a member of the Brazilian Research Network for Private International Law, the American Association of Private International Law, ASADIP, the Brazilian Association of International Law, and the Latin American Research Network on International Civil Procedural Law. He is also partner for innovation and technology and dispute resolution, specializing, I think, in arbitration and litigation at the law firm L.O. Baptista in Brazil. Now, that very nicely encapsulates your career, but it doesn't tell you everything about, you need to know actually about Professor Polido. But welcome, Fabrício. It's wonderful to have you with us.
Thank you so much, Sherry. I'm very happy to be here and be part of the CBDC project at the Hague Conference of Private International Law. So thank you so much for inviting me to be part of this interview as well and share some of the views that we have been discussing during the mandate of the project.
Absolutely, Fabrício. Now, you've alluded to it, and you are one of the experts that we have designated to the CBDC's project from Brazil. You also sit, of course, as an expert on other working group on digital assets and tokens. Now, we're aware, of course, Brazil has been one of the countries at the forefront of exploring CBDCs. And since 2017, Brazil actually has been exploring this matter of the digital currency. And of course, has just developed its own CBDC, which was recently officially named the DREX. So let's perhaps start there. If you would just walk us through an overview of this project as an introduction to the notion of CBDCs, like how does DREX operate? Could you walk us through that?
Sure. Well, DREX is a very young project, actually, from the Brazilian Central Bank, and it refers to the digital issuance of a Brazilian digital currency. And so it has the same nominal value as the paper money, so to say, and the DREX will be, as long as the central bank disseminates, an extension of a physical currency. But of course, the most application of this DREX and also the digital currency in Brazil is related to digital payment systems. Which in fact Brazil has already been developing for many years in a very innovative way, and we call it PIX, which is an instantaneous payment system integrating all the incumbent and digital banks across the country, and also giving the possibility for Brazilian citizens to be integrated to the financial system through a very innovative and distinctive digital innovation in the field of finance. So it's also experiment dealing with digital finance in Brazil. So everything is together in this same set of innovative tools that the Brazilian Central Bank, as the monetary authority in the country, developed in the last years, and also exchanging many experience with other countries in the region, Africa and Asia, due to the fact that we have a large community of people being integrated in the finance, and also people having access to finance through the mobile money approach, which is more than that, because we are talking about countries in Latin America, Asia and Africa, which are developing such projects in order to enable citizens to a financial life. And therefore, it's very important also that DREX had these particular contribution in terms to be a monetary instrument, but also a digital currency itself. It will focus in transactions between entities, financial entities. So from the point of view of financial transactions, DREX will operate on those level, at least in the terms of transactions between financial entities. And eventually the general public, as you say, the public having access will be having access to via digital wallets provided by payment systems. So there is a chain of transactions and chain of subjects or parties related in this particular financial or digital financial relationship, so to say. And this is has to do also with the operation of digital wallets that are integrated to the citizens' mobile phones and also smart devices. And this is also what this fintech-related approach of DREX also has to do with. So this is basically what we have by the time being. And second, it operates through, of course, a platform based on distributed ledger technology, so by blockchain technology at later stands. And this is one of the benefits of using the platform, because there is a possibility that intermediaries will be also interacting with banks and also citizens, clients, operating, working and using, the DREX in their digital transactions, in their daily digital transactions. So this is also something we have to do by linking financial transactions or operations to smart contracts based on blockchain technologies. Those transactions will be concluded automatically when such pre-established conditions are met. I think pre-established conditions for digital transactions are very important, because they have to be fulfilled in order to give parties, so to say, some guarantees that transaction will be secure based on integrity and also the interoperability between those transactions and the use of DREX. So interoperability between the platforms issuing DREX and the platforms using DREX as means for digital payment. So interoperability is very important. And as I intended to discuss later with you all, this has to do also with some principles that private international law, in a policy way, in fashion, has to incorporate in the future: integrity, interoperability, and also be a complement to other main overarching principles of private international law, such as legal certainty, predictability, harmonization, coordination of solutions amongst legal systems. So there are a bunch of issues that could be discussed in the way. In experimental stage, since March, DREX is now is being subject to experimental texts, and also this has to be, used from October onwards now this year, and the official launching of the digital currency should be taking place by the end of 2024, so next year. So we have a year of experimentations, which is very important. But what is more important than everything is that basically the stakeholders will be aware of the existing experimental tests and also be able to implement DREX in their daily digital financial transactions, and also to incorporate DREX in the reality of the main or the existing forms of digital payment systems, which is what DREX is basically envisaged to be. So basically, it's something what we have now in this discussion with DREX in Brazil.
Oh, that sounds fantastic, Fabrizio. If I might maybe stick with that particular point that you talked about, which was interoperability. Of course, right now, Brazil has the tangible paper and coin reals. And a lot of transactions of reals already occur through your digital platform. I think it's called Pix, is a completely different one as well. That's a digital manner of apps and credit cards and so on. Now, the DREX, of course, will have to be interoperable. It will have to work somehow together with this ecosystem. Could you maybe just give us some idea of how DREX would circulate alongside, tangible paper and coin reals, and in terms of apps and credit cards and all that? I mean, you've already touched on some of the additional benefits of having it on the ledger, having it on blockchain technology, but how would this work between these sorts of money, if you will?
Sure. So what we have basically is that DREX is a digital representation of a physical currency, which is real in Brazil. So there is this assimilation between DREX and the real, as physical real, as we say, the tangible currency, the tangible paper that circulates is not circulating so often anymore, because nowadays people in Brazil are really transacting basically by means of the use of smartphones and touching systems and so a touchless system and so on. And this is what we have been experimenting and witnessing also in Brazil at this particular stage, at this stage. But the digital currency, DREX, maintains the parity with real, saying that a ratio of 1-to-1, which is 1 real DREX, which will be. There will be also a particular abbreviation for RD, and then this will be also what DREX is intended to be. So reducing also the circulation of paper and coin reais, but will not replace cash simply because this will have a time and not everybody will be able to operate. Not everybody would be digital literate or educated to digital tools like DREX. And so also there's another aspect very important, that DREX follows all the development made by the instantaneous transfer system established by PIX solution. PIX is a digital, actually is a digital, instantaneous digital payment solution, which had enormous impact over Brazilian banking system. And I just mentioned what happened with basically all the institutions, financial institutions, banks operating in Brazil, because somehow they were incentivized and somehow pushed to abolish, extinguish all the fees applicable to those traditional, very complicated and truncated mechanisms of transfer. For example, SWIFT, international ones as well, but also national ones like the TED transfers, which would be the ones that they would apply or be used for a purpose of transferring money from one account to another, as SEPA system in the European Union, for example. So in Brazil, within the territory, those fees were abolished, they were extinguished, because no bank would be able to compete with PIX, which is an open banking system based technology. And so PIX has this innovative and distinctive feature, which I would like to remark, because this has a full effect, and I would say more chilling effect over the banking systems in Brazil. So the focus of DREX being mobile, and also the benefits of this currency in particular, is the fact that it's a real intention of the central bank, as central bank public policies, to modernize economy, to mobilize money, to provide also what we say experiment that other countries could imitate, other countries could enjoy and benefit from that. So the main objective is also to secure an innovative room for flourishing new technologies in banking system, digital money, and also the potential inclusion of financial institutions across the globe with the same purpose in DREX. So this basically is what we have, apart from reducing costs, apart from connecting people and institutions together, everything is related. And of course, it's not able to replace, for example, cryptocurrencies and other experiments related to virtual assets, but there will be some consequences related to the way how we characterize digital currencies, such as those in CBDC's projects across the globe, and also those related to the law applicable, for example, characterization to cryptocurrency and crypto assets, especially because the Brazilian legislation just excludes from scope application of a currency from the law that is regulating or governing transactions related to cryptocurrency and virtual assets in Brazil. So this leads to the point, to finish, that DREX is not an asset as such. And so it's something very important that can be used for digital payments and systems and new applications coming in this vein.
No, thank you for that. I think, in particular, I mean, the innovativeness or the innovation, let's say, in creating DREX and making it interoperable, all these systems, including the paper money, is quite remarkable in Brazil. But I think you also particularly mentioned two things. So the key characteristics of the currency that makes it work. One is mobility and its portability, even across borders. And the second, of course, is the wide acceptability of this currency for transactions. So you mentioned also a little earlier that Brazil, in this experiment, had been dealing with other countries in the region, even as far as Asia as well, and so forth. And of course, we know that some types of national fiat currency are actually accepted outside the states of their issue because of their stability, because of their global acknowledged value, for example. Now, just from a private international law perspective, you've already hinted at this. If we take the situation where possibly one day we'll have the circulation of DREX outside of Brazil, and possibly, in that sense, then the acceptance of a foreign central bank digital currency within Brazil. Are there specific unique legal characteristics of CBDCs that would distinguish them from non-CBDC fiat currency? And if so, in terms of the law applicable, can the law applicable to CBDCs be different than that which applies to non-CBDC fiat currency?
Well, this is a very good question, and I would start at also the legal nature of what has to be about CBDCs as such, and also taking into account that can be considered, for example, a tokenized version of a national currency operating also in relation or in connection with digital transactions taking place in the blockchain, basically in DLT platforms and so and also retain the characteristics of a fiat currency, which is very important. So the acceptability in another country will be very important. For example, taking into account the Brazilian experience, countries in the region such as Argentina, Uruguay, Paraguay, Peru, they accept also exchanging using the Brazilian fiat currency real, because as you say, at least the stability of the currency. If the currency is subject to any devaluation and depreciation, this has to do with the monetary policy and other economic conditions that or factors that would be altering this scenario. But in the end of the day, the stability feature would be of a paramount importance in order to keep this ability of to make the CBDC also interoperable in terms exchangeable also in those regions. So it's the same. The second is that CBDC as such, being digital, being tokenized, and so operating in a DLT platform, is compatible to technologies and will be compatible with digital technologies, and so integrated to other electronic payment systems. And I believe that this relationship between the CBDC as an object of transactions as such, and on the other hand, or means of payment, in the other side, the presence of intermediaries in payment systems will be one of the most important relationships that we lawyers have to look into. And so this is also basically because of the unique legal characteristics of CBDCs, distinguishing from non-CBDC fiat currency, such as the way how CBDCs are issued and also subject to direct control by the central bank, traceability, which allows authorities to track those transactions more easily, and also aiming at securing those transactions and preventing from the occurrence of money laundering activities, which is also the main concern. At least I'm looking into different regions in a comparative legal perspective. All the countries in international organizations, regional organizations, are very concerned about the use of, for example, crypto assets or cryptocurrency in connection with money laundering activities. So the way how a money or a physical or a digital money is controlled by a central authority, or at least a central authority that can share its authority with other central authorities across the globe in an international digital and finance cooperation rationale. And say that's why this area provides us also with a contribution in the field of international digital and financial cooperation, which in my view is also a topic for private international law, because private international law is about international cooperation. And just to finish, in case of Brazil, the law applicable to CBDCs may differ from those applicable to traditional fiat money because of the unique characteristics or features of CBDC. And I give an example. The recently enacted Brazilian Virtual Asset Act, the law number 14478 of 2022, it was enacted last year, December, expressly excludes fiat currencies from the scope of application of laws and regulations dealing with digital assets or virtual assets as such. So the central bank now is working with other authorities in Brazil to touch the regulatory effects and also the framework for the Brazilian CBDC, the Brazilian DREX. So there will be so much experimental work in this field as well.
Well, thank you for that. I think that actually is a very interesting perspective on it. That that digital currency is legally, at least, or legislatively excluded from assets or virtual digital assets. So I mean, let's maybe cut to the chase. I mean, that we are working at the HCCH on CBDCs. The mandate is specifically to look at the private international law implications of CBDCs. Let's maybe ask you just a simple question. Is it necessary to conduct work relating to the private international law challenges which arise from the use of CBDCs? And if you think it is necessary, why would you say so?
Wow, this is what I'm looking to answer. It's very, I was willing to actually answer this question, basically because we are not just talking about how private international law would be, devoted to touch those issues related to the characterization in law applicable jurisdiction, recognition, enforcement, dealing with CBDCs as such. Because the main, I think, I believe that the main idea, this is what I'm being contending, is that the concern is not about the digital relation of the use of the digital currency as such, but how, same for private international law, the transactions between financial and intermediaries, financial institutions or intermediaries amongst themselves will be of concern of private international law. So be interesting for private international law standpoint. So this is what I've been also contained in this instead. So issues related to characterization, law applicable, and also jurisdiction issues related to digital payment systems, for example, or payment transactions will be of interest of private international law. And so the potential use of CBDCs in those transactions will be, of course, absorbed and incorporated in a package of concerns of private international law, because we are talking about not only the cross-border circulation or mobility of digital currency across the globe, but we are talking about the mobility of digital transactions, for example, digital payments transactions across the globe. And those payment transactions, as today, from the international financial legal point of view, have unique characteristics that are of interest of private international law. If we look to the past, for example, the Hague Academy of International Law lectures, there were lectures from very prominent private international law scholars dealing with international financial law and also money as the legal nature in characterization from the point of view of private international law. So we are just going back to the basics and to our original and, very core issues to bring back to the new reality of the digital innovation in the field of digital innovations in the field of private international law and digital innovations in the field of global finance, which is also very important. And it will definitely create challenges in terms of determining law applicable jurisdiction over transactions involving digital payment systems integrated with the use of CBDCs. So this is the work for jurists, for lawyers in any kind of region, in all the regions in the globe and in different traditions, even civil common law approaches and whatever. But this is very important. So we are also tracing aspects related to cross-border litigation, contractual issues, civil liability, property rights. So everything that has to do with private international law in first instance, and second, the possibility that private international law will touch upon issues related to those cross-border payment transactions, and cross-border payment transactions also integrated with the use and circulation of digital currencies. I don't know if I answered, but those were the ideas I had when I was thinking about this interview.
Well, thank you so much, Fabrizio. I think you more than answered it. And if I might just probe the angle that you brought up on payment systems, in particular cross-border payment systems. Of course, you mentioned, digital currencies as something that's important in the sense of the international financial system, in terms of using currencies across borders, going back even to the basics of what money is, and the conversations that we've been having at the Hague Academy, for example. So keeping that in mind, when we're talking about cross-border payments and cross-border payment systems, now obviously CBDCs is the focus of this colloquium, but of course there are other jurisdictions that don't have central bank issued digital currencies, but have adopted cryptocurrency as legal tender or as what they will accept as money in their systems. Maybe with that aspect, could you maybe give us some insight into what aspects of CBDCs make them unique from cryptocurrencies, even those that are accepted as payment forms in certain jurisdictions?
Yes. This questions brings our attention to not only the distinctions between cryptocurrency and like digital fiat currencies that are under CBDC's projects across the globe. It's a very important aspect, as I would say, a policy issue for domestic institutions, governments, legislators, and so on, but also at international level, a policy issue to be taken into account. Because, for example, unlike a cryptocurrency, a digital, at least what we are envisaging, a digital currency, fiat currency, will not have any kind of price variation or fluctuation according to the speed and the occurrence and frequency of the transactions taking place into the platform, into the DLT platform. What is quite a characteristic or a feature of cryptocurrencies transactions. So they are subject to the fluctuation and also the price variation through this particular market of cryptocurrencies. This is a very important aspect to say. The second, that it's an essential feature that CBDC is issued by a central bank or other monetary authority of the relevant jurisdiction and is centralized, because it doesn't seem, at least as we are exploring this project, as we are really deep investigating this in the background materials and documents, and also the policies that are already public by the governments and central authorities, that CBDC is not subject to a decentralized structure, right? So any credit that the CBDC offers to a holder is also direct responsibility of the issuer. And this is an idea that distinguishes from other instruments and represents a piece of credit or a piece of representation of a nominal value that could be subject exchange transaction or payment transaction, which is. So for digital currencies such as CBDC, also it will be requested that parties in transactions also have evidence of data such as address, identity, to monitor those transactions, and the accumulation of wealth, with something very unique in the, of course, is unique in the capitalism system, as we know. So capitalist systems like that. And in the case of cryptocurrencies, privacy is much greater, of course, by the cryptography of every single transactions, and also that the information related to cryptocurrency transaction is not addressed by public authorities, not addressed by the regulator, the watchdog institutions. So it simply goes from one wallet to another wallet without any interference from institutions or states. So it's just about non-state law regulating or operating to design those transactions. I assume that is not the only solution for those issues particularly. So that's probably what distinguishes from one to another. And cross-border payments, if we have cross-border payments in mind, also there will be some much effort from states and organizations such as the HCCH to engage in a very proactive role and policy working in this field to really go deep into those questions related to law applicable, which has to do with the prescriptive jurisdiction of any state, and also go deep to jurisdiction, which has to do with the adjudicatory jurisdiction of any state, and how to enforce decisions, which has to do with the enforcement jurisdiction of states. So the jurisdiction, the whole jurisdiction approach, also very important in this case, and the role of state law also in this area. And therefore, I believe this has the uniqueness or singularity of CBDCs in relation to cryptocurrency, and how private international law will look into those issues deeply.
No, thank you for that. May I perhaps kind of drill down onto this thing that you have brought up earlier on a matter of proprietary interests? So you've of course given us the example of Brazil having excluded from its digital assets definition in its law digital currencies rather, as a separate category. And I'm just wondering, are there unique proprietary rights and interests which arise in the issuance, the circulation, the use of CBDCs? Is there a property law kind of question there? What kind of proprietary issues might arise?
Yeah, I think if we look into exclusively to the CBDC as such, If we talk about the issuance, circulation, and use / application of the CBDC, so we are also thinking about how this issuance, circulation, use of CBDC will generate a series of legal or create or legal rights and interests. For example, in case of DREX, the central bank still retains the exclusive right to issue CBDC, which gives Brazilian central bank the control over the creation of the digital currency and also control over the quantity and circulation, which is typically a principle in monetary law. Central bank has the power to define monetary policies related to issuance. So therefore, this has to do with a discussion that we can see in a later stage, which is about the public proprietary nature or feature related to the CBDCs. So if they are considered assets belonging to the central bank, which has the power to control, the power to share, the power to make it circulating, the power to also to somehow withdraw from the financial system. So this has to do with proprietary matter, which is a quite aspect that we also are looking into when we talk about the nature itself, the legal nature itself. But also the users of CBDC may have privacy interests since transactions can be recorded and tracked. So this recordability and traceability of those transactions may also give rise to other interests and legal interests, which is something that we have to look into that as well. And so the protection of, for example, not only proprietary rights, but also other interests such as privacy related interests that can be a relevant issue to be listed or at least listed in this study that we have. And so basically, in the case of the Brazilian DREX and CBDC, the central bank has already stated that the levels of security and privacy operations must remain as those already carried out by the banking payment systems. But the control and the power to, once again, to issue, to make it circulate, and also eventually to define how the currency can be used is from the central bank. So there is a hybrid somehow approach between those interests from the central bank as holder of the currency as such, and the other hand, from the parties users of the system, intermediaries, and also those are using the CBDCs in order to further these those aspects as challenges also for development of CBDCs. So basically, there are lots of issues related to that. And once again, I believe that it has to do more with such payment transactions than even restrictly to the currency itself, the digital currency itself. Mm-hmm. So that's why our CBDC project can focus or target a particular aspect from, for example, cross-border financial, in this case, payment transactions, the mobility of intermediaries, and how these legal persons, intermediaries, can also be touched and somehow also they can reach it by private international law, which is something unique in our perspective.
Well, thank you for that. I think, I mean, in particular, I mean, the hybrid nature of these cross-border payment systems. I mean, they're probably more than hybrid, it's tribrid and quadribrid probably, because you have all these different forms of payment methods, payment mechanisms which circulate in this sort of, payment systems, especially across borders. Now, you've touched on this already, but I think it would help us and help our audience perhaps if you go a little further into the matter of legal tender. so something that's legal tender. Now, obviously, there are certain jurisdictions in South America, in particular LATAM, who have adopted cryptocurrencies as legal tender. They also, they don't have central bank digital currencies. There are some states like Brazil who are on their way to the adoption of actual central bank digital currencies. How do you think, as a matter of legal tender, would these kinds of different legal tenders interact?
Well, I think, for example, in the case of using crypto assets as legal tenders, for example, my contention is that different ranges should be taken into consideration, in which their use does not affect only the architecture supported by central bank, for example, or the issuance of CBDCs. In the case of few countries in the world has already had, for example, Bitcoin as a legal tender, such as Central African Republic, El Salvador, and so on. It would depend on how the central bank's structure defines the limits and also the uses related to these kind of legal tenders and the crypto currencies as such. So this also has to do with the way how capital distribution is made, how the risk of systemic failure is mitigated. And systemic failure is one of the most important concerns in the regulation of international banking system and also domestic banking systems. So this has to do with also several factors that has to be considered in this case. In some cases, states may allow both cryptocurrencies and CBDCs to coexist, which is quite, I think, a vibrant trend that we are going to experience and witness in the future. And also that could be very interesting if we say how legal tenders, as if we admit that they are legal tenders. So legal tenders such as crypto assets, and the other side, CBDCs are together integrated and working or operating in an interoperable way or interoperable fashion. And so those two virtual assets will be explored. And this will involve the creation in payment systems that allows the direct integration, and more than that, the conversation between cryptocurrencies and CBDCs. So this is basically what we have been also following in the discussions here in Brazil, in the region, when talks about the existence of a legal regime for like promoting, fostering the use of cryptocurrencies on one side, and on the other side, the use of CBDCs as a powerful vector and also factor to promote the ability of parties and intermediaries to engage in those payment transactions in an interoperable integrity and also in a cooperative way. So this is what basically we have been looking into when we talk about those issues.
I should unmute myself, but before we leave that particular topic, perhaps, would you be, I mean, you've mentioned this already, the Brazilian law has split the categories of central bank digital currencies from digital assets. Could you maybe walk us into how, the national legislation there or any judicial decisions treat CBDCs differently than other types of digital assets? And how do they do that? Are there specific laws that define the digital currency? Could you help us there, please?
Yes. Are there many examples of like Brazilian legislations and now regulations touching this point, and also case law, which is also recent, but very promising in a way to distinguish those legal regimes, which I believe for the from the legal standpoint, this is very important. So in Brazil, digital assets are governed by the Brazilian Virtual Assets Act, which was enacted last year in 2022. The law provides several several general guidelines for also further regulatory policies. So it empowers the central bank, like the central authority, to define the proper regulatory framework for those virtual assets. So this is very important. There has been also a joint work between the Brazilian Central Bank and the Security Exchange Commission in Brazil, the CVM, which is the abbreviation of the Brazilian CEC Committee, SEC Commission Authority. This is the first. The second is the BVAA, which is the Brazilian Virtual Assets Act, established a set of definitions that may impact further regulations in Brazil, because the regulatory authority cannot contravene what the law establishes because of authority and different powers. So basically, they exempt the application of BVAA to some other categories. For example, fiat currencies, securities, and financial assets. So fiat currency, securities, and financial assets are excluded from the definition of virtual assets, which means that fiat currency, physical or digital, will be not included from the standpoint of the definition of virtual assets. So there will be a great room for global regional legislative work and debate on the classification of crypto virtual in already existing classifications, and also the way how we are going to deal and otherwise frame, if so, the category of CBDC as such. So we have much room to explore.
No, that's fantastic. Now, Fabrizio, I might just turn really to the private international law questions that would arise. We've already mentioned proprietary interest. Obviously, there are also contractual matters, which would impact when the CBDC is used somehow in relation to a contract, for example. But perhaps, you've already mentioned this matter of transactions and how, cross-border transactions in particular is actually the overarching topic of what we're speaking of, and CBDCs is one part of it. Could you maybe kind of walk us through what private international law issues may be considered or may arise when the CBDC is the subject of a transaction like this across a border?
So basically, I think we can discuss about, of course, proprietary characterization of proprietary legal matters, for example, those dealing with ownership, possession, custody, determine who owns and controls a digital asset. In this case, if we talk, it's just controlling a digital currency. And this can be very complex, especially in those cases that we are talking about shared custody, joint custody or so, and the use of multi-signature wallets, also having a transient or permanent control or custody of that particular CBDC or the currency itself. So this is the first aspect. The second is a contractual one, because from contractual standpoint, the execution of smart contracts, or even if we say the conclusion in execution of financial payment transactions will lead to different questions from the standpoint of private international law. If we're talking about, for example, a private permission network, parties can create smart contracts that are only accessible to authorized participants. So how would be a potential external party having not control, because this would be in other sense proprietary issues, but how the other parties could, for example, issue or be guaranteed by a transaction, a payment transactions that has been concluded between parties in a country A and a country C. So this is not out of question, because this is the reality of international financial transactions. So this allows them to define specific and personalized rules for their transactions, or private international law, we have a role to be played in this connection, and it allows parties to have those particular instruments for determining. For example, the rules of applicable law to contractual aspects of transactions involving CBDCs, for example, cross-border payment transactions can vary depending on the number of factors, including jurisdiction, also in which the parties are located, countries in which the parties are located, contractual provisions are between them, and even the incidence or application of the principle of party autonomy in this relationship. No, so how also traditional questions related to fraud to law or fraud against law, and also the manipulation of connecting factors will be also related to the way how those transactions are structured. So the architecture of those transactions will be of interest of private international law as such. So choice law applicable to those digital or payment transactions will be also of very interest of private international law. And depending on the law applicable, of course, other questions will arise, such as how the transaction, the contract is construed, and also how the applicable law is interpreted and applied to that particular transaction. So it's another issue that we can see. And also situations where the absence of choice of law applicable, and also in the fact of the parties had unlawfully choose the law applicable. So in the presence of a non-valid choice of law, also we will have questions to define, and also private international law rules and policies can assist parties in determining which law will be applicable to the contract based on those connecting factors that we still have to list. And finally, when considering, for example, consumer protection, consumer laws applicable over those transactions, in some of them will, if they're not talking just banks or intermediaries and banks, we are talking about the parties, individuals that are having also involved in those transactions. So in those cases, we'll have probably issues related to the essential distinction between B2B and B2C transactions, because those are very important. And I would go further in C2C transactions, like users to users in the internet. So individuals transactioning based on the use of CBDC or other virtual assets, how the applicable law also will play a very important role in this transaction. So and then overriding mandatory rules that can be also taken into account in case of protection of vulnerable or weaker parties. So we have also room to unfold in this area.
Oh, fantastic. I mean, I think you've given us a really good overview of all the private international law issues that could arise. And in particular, I think what I really took away from what you just said is really the democratic access to finance. So we were talking about user to users. We're talking also about protecting against the digital vulnerabilities that come up, in digital economy. Aside from educating, of course, the users, how the legal framework in terms of applicable law, jurisdiction, and so on, can help users, basically people like you and me, when we're actually using the digitization of our money system, of our payment system across borders. And I think that will help, with the global, access to capital, access to finance, and to financial inclusion as a goal that we would like to achieve. Now, you've touched on legislative jurisdiction, and in terms of adjudicatory jurisdiction as well. But I wanted to touch on this chapter that you wrote, an excellent chapter, really, which is titled The Judgments Project of the Hague Conference on Private International Law, a way forward for a long-awaited solution. Now, of course, this was in the book Diversity and International Law, and focuses on the 2019 HCCH Judgments Convention. Now, that, of course, is the recognition and enforcement of foreign judgments across borders in civil and commercial cases. Now, could you maybe just briefly tell us about this work? And in your opinion, does the recognition and enforcement of judgments and CBDC system fall within this convention? What do you think?
Well, I really have a very special, I would say, a very special feeling towards this chapter in the book organized by Professor Veronica Ruiz from Edinburgh and Professor Nukta Takela from University of Buenos Aires, very dear friends, very proactive lawyers in private international law in this bridge between Latin America and Europe. And my special contention in this chapter was to look into the aspirational goals of the Judgment Project as such, since its inception in the 90s through the work of Professor Arthur von Mehren from the US, and also how the US promoted the first draft of what would be an embryonic proposal of the Judgment Convention. Of course, the Judgment has a long history. It's very, very interesting, very fascinating. And when I look back, when I started being part of the Brazilian delegation during the resuming phase of the Judgment, I was so deeply grateful for that opportunity, because it also gives me the chance to write in a different way, because while many European writers in private international law in other parts of the world were writing just about the technicalities of the draft convention and the provisions of a convention for circulation of foreign judgments, I was focusing also on the international political reasons why it was important to adopt that particular convention, and how it would foster not only the circulation of foreign judgments, and also allows that the parties would have the right to have those legal transactions and legal relationships recognized in every single part of the world where the convention would operate. So this also international cooperative vein of the convention is very important, because it's not only about cross-border civil proceedings or cross-border litigation. It has to do with aspirational goal for private international law to ensure that cross-border legal situations and cross-border legal relationships would be preserved, would be taken into account in a different jurisdiction, differently from that jurisdiction where that legal relationship or situation was created or came into existence. So existence, permanence, and eventually extinction are the life of legal cross-border legal transactions and situations. So that was the main point. And then also has to do with what we are discussing, CBDC's project, if you are talking about the way how decisions on disputes related to financial or payment transactions using CBDCs will be forwarded to national courts, and based on recognition law, international recognition law, in this case, the successful Hague Convention of 2019, those issues will arise. So basically, if we talk about contractual nature of that transaction dealing with the cross-border payments using a CBDC, so it basically can enter into circulation through by the hands of the Hague Convention of 2019. So, of course, this is aspirational goal. And just to finish, what I consider very important is the way how we project such concerns, which are not only pure concerns, but they are more like systemic goals of private international law, which have to do with coordination of solutions amongst legal system, which has to do with harmonization, uniformization of issues related to law applicable recognition and jurisdiction, as we know, which has to do with mutual trust in legal systems across the globe, because we are talking in the end of the chain, the judiciary delivering decisions that can be taken into recognition systems. So mutual trust, international harmony, in this case, also coordination legal systems, international cooperation, continue to be the main systemic goals of private international law. In a finance integrated or financially integrated world, I would say feasibly possible with the use of digital applications, in this case, digital innovation such as those in finance, we wouldn't see any light in the end of the tunnel unless we go through those particular rationales and goals of private international law. And so to say that there are parallels, also projects that can be coordinated together, but as long as we are talking about private international legal issues related to cross-border financial transactions, and also the circulation issues of CBDCs, we would look to and bring back those principles that are very important in terms of what we have. So this is about what diversity in private international law has to do.
Thank you so much. I mean, I think that's a wonderful point on which, to almost conclude this interview. You've given us a cornucopia of food for thought, really going back also to the basic principles of why we do private international law and what's the point of it and so on. So just let me kind of thank you there for all the insights and the expertise. Thank you so much, Fabrizio. It's always a privilege to learn so much from you. And thank you so much as well for your time, that you've invested not just in this interview, but also for the CBDC's project. Thank you.
Thank you, Jerry. Thank you, everybody that will be watching to this interview. And I hope to be in touch with everybody interested in this topic as well.
You might get an avalanche, but thank you so much. For our audience as well, then, we were just in conversation with Professor Fabrício Polido, who's Associate Professor of Private International Law, Comparative Law and New Technologies at the Federal University of Minas Gerais in Brazil. He's also a partner at the law firm L.O. Baptista. Thank you so much, Fabrizio. It's been such a pleasure speaking with you, and we'll be in touch.
Thank you, Jerry. Thank you so much.